friends, how are you? I hope everyone will be fine at their home in this pandemic situation of corona and you are taking care of yourself and your family. This is Dr. Meena Singh. Once again, welcome everyone on your YouTube channel. As everyone knows, this channel I have prepared for you and for your study. So without waste of time, let's start today's topic. Today I brought very much important topic, and that is what are the differences between litigation and arbitration. So here I am going to cover what is meaning of litigation, what is meaning of arbitration, and what are the differences between litigation and arbitration, and after that what kind of cases can be resolved using litigation, and after that, why international trade disputes takes place. So guys, let's see one by one what is meaning of litigation and arbitration. So, before that, see, when disputes arises in business, then litigation and arbitration are the two important methods to settle the national and international disputes. So let's see who is arbitrator. An arbitrator is an independent, impartial third party that works to settle a dispute between two opposing sides, often by making a decision that they both agreed to. This process is called as arbitration. So let's see what is the meaning of litigation. So litigation means taking a dispute to court. It is a public procedure. Arbitrator can solve any matter easily within the short period of time, whereas litigation is costly and time-consuming process. Arbitration is always civil in nature, whereas litigation may be civil or criminal. The place for arbitration of the issue is decided by the party, whereas litigation takes place in the court only. Next point is here. Arbitration is a private dispute resolution process in which the parties present and submit their case to a single arbitrator or a panel, and panel issues a decision on the case called an award. In litigation, if parties cannot agree between themselves about their fair and proper outcome of a dispute, they will present their respective cases to court for its judgment. Guys, this is also one picture of the litigation and arbitration. In litigation, parties may be compelled to participate in court proceedings, whereas in arbitration, we cannot compel another party to participate in arbitration unless you have a contract there requires. Next point, in litigation, the trial judge is assigned by the court without input from the parties involved. Whereas in the arbitration process, the parties choose the arbitrator, often based on expertise in a related field of law or industry. So dispute resolution is the solution of the arbitration and litigation. The main difference between arbitration and litigation is that in litigation court is involved, whereas in arbitration a settlement between the parties is done outside of the court. It means in the arbitration court is not involved. Next point, litigation can be more expensive than arbitration due to lengthy process, whereas arbitration can be less costly due to the compressed schedule. Next point, litigation is a public procedure, whereas in arbitration, resolving issues between parties are confidential and private. This is example of arbitration hearing. This is example of litigation in the court. Now guys, let's see what kind of cases can be resolved using litigation. So there are two types mostly. First one is commercial disputes. So second one is employment disputes. Let's see first one point. Claim for breach of contract such as damaged goods or recovery of debts will come in the commercial disputes, whereas employment disputes claim for wrongful dismissal will come. This is one example. Arbitrator may be single person or team of people. In arbitration process in which the arbitrator's decision must be accepted by both the parties, it means arbitrator's decision is final and legally binding. Now guys, next important point is why international trade disputes take place. What is the reason behind that? So there are also many reasons for trade dispute. First one is when time is considered as the agents of the contract, but goods are not supplied within the stipulated time. Second point, when the overseas buyer refuses to pay or delays payment. Third point, when goods as promised are not supplied according to description. Fourth point, disputes may also arise due to passing of property in goods, that is ownership, passing of risk and on account of title to goods. Fifth point guys here, when goods supplied are not of merchantable quality, for example, goods do not have use value or exchange value. Sixth point, that is also very important, when the promissory expresses difficulty of performance due to some uncontemplated events, delays, etc., although he has undertaken an absolute obligation to perform the contract. Guys, let's see what is the conclusion of this topic. After reading all the points, according to me, all the above, I think that arbitrator is the better dispute resolution. So guys, if you like my hard work, then like it, subscribe it, and also send it to your friends. You can also follow me on Instagram and Facebook. Thank you for watching this video.